I have previously reviewed the files submitted in this case, and I understand that this is a request by Ms. Jarvis to seek return on $3,547 of money that she paid back to the HOA for Harbor House based on the HOA's request that she believed had originally been approved by the HOA under the prior president of the HOA. Is that an accurate summation generally of the issue before the court?
Yes, it is.
Okay.
Well, he was an unpaid.
Go ahead, Ms. Adams.
He was an unpaid manager.
Okay. But he was the president of the HOA at the time, or whatever it's called.
No, he was the manager.
Okay.
Why is it? It's backfeeding. Did I do something wrong?
No, you're coming through appropriately here.
Oh, okay.
Whatever.
Anyway, he was the unpaid manager, and he was very ill at the time.
Right. He passed away shortly after this happened, I think.
Yes.
Okay. What I'm looking for, and as I said, I reviewed these last week, and I thought I remembered seeing something, an email or something, Ms. Jarvis, from Mr. Riley. Is there one in your exhibit, or is it your memory of the conversations you had with him? I can't recall now.
Yes, there is an email here that talks about setting up a meeting to discuss the electrical issues as well as some other things. I'll give you the page number. Let's see. It was an email starting on August 5th, and then we met on, I believe, August 11th, or sorry, Monday, the following Monday.
All right. So what I see on page 51 is a response from Mr. Riley, who says Monday at 11 works for me. And you had your initial email had made a request concerning some of the issues set forth under your topics heading. Is there anything else in Mr. Riley's, any other written documentation of Mr. Riley's position on this? Do you have any confirmation emails or anything saying, yes, I'm agreeing that the HOA should pay for the electrical upgrades to the storage unit or shed? Is there anything?
Okay, his approval is demonstrated by the fact that he paid. And when Woods Electric did the work, he asked for the Woods Electric bill to be sent to him. They made a mistake and sent it to me. And I believe there's something in this packet that shows, let me get to a page here, shows him asking for, or them asking for the new address. Okay, so that would be page 58. Again, Jerry is saying, please have them send the address to me, send the invoice to me. And it was mistakenly sent to me and had to be resent to him. That was his request because he fully intended to pay for it.
Okay.
Can I comment on that?
Yep. Yeah. I'm going to get to you, Ms. Adams.
Okay.
First. I'm just trying to get the basis of the plaintiff's case first. All right. So, Ms. Jarvis, what I see on 58 is an email from you to, I'm assuming, Woods Electric, saying, please send it to a different address.
Okay, so on 58, the email is basically, the name Ken is the estimator from Woods Electric. And I just wanted to let him know that Ken's going to be sending him the invoice, but I just needed to be reminded what his address was. I didn't know it.
Okay. So technically, I mean, the email is from you. It's not Mr. Riley's words, but I'm your argument's going to be, I wouldn't have sent that if Mr. Riley hadn't told me to make sure it got sent to him.
Exactly right. Exactly right. And yeah.
All right. And Ms. Adams, you are currently the condo manager, is that right?
Yes, I'm the unpaid manager.
Right. So give me some idea, since you are serving in that capacity, what do you believe to be the authority of the condo or HOA manager?
Oh, there's nothing really other than they make the decision. The condo association makes the decisions and I execute them. That's pretty much it.
Okay. So in this case, it appears to be an upgrade, probably by the installation of an electrical panel into a storage or into a shed. I'll just call it a shed because I'm not sure what it's used for, but I think I read in some of the defense exhibits that that's, you view it as the personally associated with Ms. Jarvis's condo because she has a lock on it and it's right outside of her unit. And it's not a common facility, and Ms. Jarvis has been arguing that it's a common facility that should be supported by the assessments of the HOA.
Can I clarify that for you?
Yeah, please do.
Okay.
There's a lot of documents in here, so that's why I'm asking questions.
Yeah, it becomes confusing, and I think that's one of the things that Jerry got confused on as well. There is, under her bedroom, there is a storage area. And that has been considered by the current owners of the property here as a common area, and I can give you a whole bunch of reasons. But anyway, the thing is that there's also the shed, and the shed is Unit 3's personal property, and it's actually on her title. The common storage area is not on her title. It's actually listed in the square footage on the declaration for the association for common areas. But she did receive something that showed that on a different listing, a different filing with a different number, it shows that it's her unit. So it has become confusing just in the last few days because we both didn't know that there's a difference there. Okay, so let's go back to your others.
Well, okay, let's just stop right there because I want to make sure I understand this. And the dispute is not about the basement storage area. The dispute is about the shed. Is that correct?
Yes, although she started that they're saying that there was electrical problems there. I have read through all of the inspector's report, the home inspector that she had, and the electrician bids that she got. I do not see anything except that she wanted to upgrade the look. It had just been a light with a string, and it now has a switch, with a button to push to have it come on, and also a socket next to it. That's it in the storage area. In the shed, it had to have a fuse box replaced. It had to have it rewired through the whole thing, and it had to be wired from the shed to the main building. So therefore, that's, and we didn't get asked as to whether we wanted to have it upgraded in the storage area at all. So therefore, that's where the problem is.
Okay, so the $3,547 paid for both, paid for one. Tell me.
Okay, it paid for everything except we did not charge her for the tree light replacement that the electrician. Yeah, we are paying for the electricity on that, and that's fine. We just don't want to pay for the electricity in her private shed.
Okay, so, but you said some work was done in the downstairs storage unit.
Correct.
And then other work was done on the shed. And so the $3,547 that Ms. Jarvis has paid back at your request to Harbor House, was that money just for the shed, or was that money also for the storage unit downstairs?
It was for both.
Okay, and do you know, can you break out costs? Which cost goes to the shed and what cost goes to the storage unit?
I don't think we can from the it being D of mine, because we've got Woods's electrical on there. I don't think
Okay.
we can. I don't think there's a way to do it. Sorry, Nathan.
Okay.
Yeah, I don't have enough detail to do that. No.
Okay.
And she required it. We didn't, if we had been asked, we would not have paid for it. It was sufficient as it was. And none of the home inspector nor the,
It wasn't grade to what is deemed a common area, is that correct?
yes, it had been for 20 years, but Miss
Okay.
Jarvis thinks it's her private area.
Okay. No, I'm not talking about the shed, I'm talking about the storage unit.
No, she
underneath.
said it, the storage unit is hers. That's why she put in the lock between my apartment and that common area, that storage area.
Okay, so is there a lock on both the shed and the storage area?
No,
It's, yeah,
no.
no, there's none on the storage area to get into it from the street. But between my private patio and that common area, there is now a lock.
I don't know how it got there. I didn't put it there.
Okay. All right. So is there a dispute so I understand that I'm hearing that there's a basement storage unit and do you both agree it's common area, or Ms. Jarvis, what do you think of the basement storage unit? Is that yours or is it common?
Your Honor, I submitted some maps that I was given when I purchased the property, and included in condo 3 is the basement storage area, the shed, and then another open area that is indicated on the maps. That's on page 8. And it's recorded. That's what the assessor says is part of unit number 3. I have exclusive use of the basement storage, the shed, and an open area that is between the two. And all of this electrical work is interconnected. It's not standalone. One doesn't work without the other. The shed doesn't work unless the basement is fixed. The tree light doesn't work unless the shed is fixed. So it was an upgrade, repair, bringing everything to code, taking care of safety issues that were a fire risk. That's in the report by the inspector. It was done under the guidance of the HOA manager, his tutelage as far as what the process was. I, as a new condo owner, didn't make this stuff up. So what did the process of finding an electrician, working with the HOA manager to figure out what was the best approach. He added some things to the original plan based on things he thought the other owners would really appreciate. And I project managed it to the completion where he was given the invoice and he paid it almost a year ago.
Okay, so let me say you indicate the maps you saw that you relied on and you believe the assessor is rating your unit on tax liabilities for as to include both the basement storage and the shed.
Correct.
So that would, I think, strengthen Ms. Adams' argument that the work was done privately for you and should not have been paid for by the HOA. So what's your thought on that?
Well, my thought is that I don't own or control the wiring inside the walls or ceilings of my property, which is identified as Unit 3. That, whether a condo owner can be held responsible for repairs of the electrical system in the condo building is really the question here. And RCW 6434-204 states that the condo owner only owns and controls the interior of their unit, essentially from the paint in. So I have exclusive use of these spaces, but I don't own the building. I don't own the structure. I don't own the conduit, the wiring, the walls. I just have exclusive use, like I have exclusive use of this condo from the paint in. And that's what I'm going on, is the level of responsibility is from the paint in and the floor up. But the structure of the building, based on what I've seen in the CCNRs and the Washington statutes, is that, things like wiring and conduit, roofs and antennas all belong to the HOA for the condo building.
Right. But just hypothetically, I mean, if a unit owner decided to put, I don't know, dance lights in their condo, which required special wiring, is the HOA then obligated to do that?
That's a pretty radical example. I don't think so.
It is, yeah. This is how lawyers work. We're looking at what the argument it is and seeing how, if it stretches credulity, then we have a problem with it. So, I had read what you said and quoted the statute, which said that the electrical circuits are the common obligation. And that makes sense, of course. But if they serve only one purpose, then that diminishes the ability of the electrical circuit to be a common obligation as opposed to the obligation of the unit owner. So tell me your theory on that.
I guess my theory is that when you talk about safety, so when my inspector flagged that there was a serious safety issue with the wiring, which was on the back of Carolyn's condo and underneath mine, that's when I went to the HOA manager and said, this is an insurance issue. I mean, it is something that is too high a priority to let go. I know Carolyn thinks I asked for the electrical work to be done cosmetically because there was just a string on a light. But bottom line is, this gentleman who was our HOA manager for 18 years agreed it was too important to take care of on behalf of everybody. And it's not optional. The safety is not optional, and it impacts all of us, not just me. Okay, so the dance lights are optional. In any case, I think that, as a condo owner, working with the HOA manager at the time, I think I did the right thing on behalf of my space and all the other unit owners. I don't know why this electrical had been such a disaster and people hadn't taken care of it before. But as a new owner, I want to make sure that the place was safe and that I followed the rules to get it taken care of as quickly as possible so we could all not worry about it. And it's an electrical upgrade, repair, bringing things to code, making things safe, that it's all interconnected. And yes, I use the space as I share that space. To be honest with you, I share that space with the other condo owners, even though it's exclusively my space. The shed I don't share. Why? Because I've had vandalism against my mailbox. And I don't trust that I can leave my shed open because I have a wine collection in there. So for that reason, I lock one of my personal spaces and I share the other space with Carolyn and the other owners. But again, I think it's really important for everybody to acknowledge that for all these pieces to work, it wasn't a one-shot repair. Everything had to be fixed together. They're all interconnected.
Okay. And Ms. Adams, if there was to be an expenditure by the HOA to fund, upgrade and necessary services like power or water or sewage or anything like that, do you have the authority as the manager to make that determination and go? Is there a defined process for that? How does that happen?
Okay, water and sewer and garbage are actually taken out of the HOA fees. That's how we pay for them every month.
Right.
The electricity is actually each individual condo owner has to go in front of Puget Sound Energy and contract for their electrical. That's why in 2011, August of 2011, we actually set up 5 different electrical panels, one for each unit. And each owner at that time had to pay for that electrical panel. And then they assumed all of the risk for the wires that go between the panel and their condo or their private property in the case of the shed. The rest of us don't have that. But anyway, so that's what occurred at that point. And so we do not consider the electrical as anything to do with the condo other than if something occurred between the street where the electricity comes in and then goes to the big circuit board, which I put a picture in there for you. Other than that, we would handle that, but we wouldn't handle anything other than that with electrical.
Okay.
Okay.
So from the point of the panel, you stop paying as the HOA and you expect each individual owner to be in charge of the condition of the wiring from the panel to their unit and all the appurtenances to their unit. Is that?
No, they're actually responsible for the electrical panel itself. I'm just saying that, there's a pipe that comes in the bottom of the 5 electrical panels where the whole electricity comes in, and then I'm not sure exactly how it works, but that's how it somehow or other, when somebody uses their electricity in their unit, it gets measured, and that billing goes to Puget Power, and each individual owner pays their own electric bill. So the condo has nothing to do with that.
Okay. Okay, so 2 things. One is your theory is that Ms. Jarvis said she had an inspection which said the wiring was not safe bringing the power to her unit, and that's, she began this electrical effort in order to upgrade the wiring for safety purposes. And it's your belief that that is the obligation of the unit owner, not the obligation of the HOA.
Exactly. And I actually, when you look at the bids that came in that Miss Jarvis collected and her home inspection, there is nothing that talks about fire hazards. That's where she did get Jerry's attention, but we don't think he ever saw the bids and the home inspection. When you look at those, and I went into big detail on that with my statement, evidence and all that, because I had to type that up because I had to get the other owners to agree with what I was saying. That's why it's prepared. Anyway, the thing is that there is nothing. It talks about grounding problems, and that's your safety. But she says it would be a danger to any of the owners, their guests, or there's another word that she uses. And that's not true. A grounding is if you go into her shed and you use the electrical in the shed, you could be shocked. The other one was a fuse box, and it says that a fuse box, when used in tandem with an electrical panel, is unreliable. And so therefore, that's what they said for her to change it to a circuit board, I assume, or electrical panel. But there's nothing in there that says it's a fire hazard.
All right, so back to my original question, what's your authority as manager? Can you make decisions about
good
HOA
question.
improvements without the board? Do you have to take everything to the board?
Unless it's been something like, for instance, I can I can get the handyman out and have him do the jobs that the condo has given permission to do. In order to do a new project, I have to get the permission of the owners, and it's particularly brought to, it's in rule. If you go to our bylaws, on, on 39, page 39, you will see that there, it actually has it, I believe it's number 3. On there, yeah, it's number 3. It says no major improvements shall be made to the common areas without the consent of the majority of the management group. Now, this would definitely be a major because it was 40%, 46% of the amount of money that we had in the checking account. And I had to pay the insurance within 4 months. So that's major.
Interesting that Jerry didn't ask for a vote from anybody. He and I just worked together, and you're his right hand, feet on the ground. So I'm surprised that he followed a different process here. I mean, at no time did he indicate that he had to check with people or get a vote.
Okay, so sounds like there wasn't a vote. There's no history of this issue being raised with the HOA board.
No, the owners were surprised that they did see all the work going on. They did, but they did not realize that the condo was paying for it.
And you said that it's Article 39, is that what you said?
It's the bylaws. It's on page 39 and it's number 3. I have an arrow in front of it. It says no major improvements shall be made to the common areas without the consent of the majority of the management group. It's the bylaws. And Jerry was very ill. In fact, the week after he supposedly met with Ms. Jarvis on the 11th, he had a major seizure. He was in St. Peter's Hospital for a week, almost a week, because of this, and his wife said he went downhill from there, which is attached as evidence under manager's health on page 57.
Right. Yeah, I read that.
Okay.
Unfortunately, I wasn't privy to that information. So although we really mourn the loss of this man, whenever I worked with him, he seemed fully functioning and clear thinking and fully in control of the HOA funds until later in the year when he suggested he needed to step down.
Well, I actually didn't know that he had a brain tumor. I knew he was ill, but I didn't know he had a brain tumor. And I'm very familiar with that because I nursed my father-in-law until he died in our home. And the deal is that they had told us at the hospital that we had to bring in a certified nursing assistant to be with him. And I didn't understand that because he was totally and completely rational to us, to the family. As it turned out, one day the CNA didn't get there on time. So I went rushing back home, and the CNA and I both walked in together, and he had started a fire on the stove, and he was just sitting there looking at it. He didn't know what to do. And this man had run his own business.
I can't ascribe that to somebody else. I understand.
Yeah,
what you're saying.
but you think that they know what they're doing when they had a brain tumor, but they don't.
Yeah.
That's what I'm saying.
Well, all right. Well, I'll say I actually have a brain tumor, so I hope you hold me to that same standard because I think I know what I'm doing.
Okay.
All right. So it doesn't, one person's experience isn't necessarily another person's experience in that regard.
Yeah.
So I've opened up your version or your copy of the Declaration of Covenants and Conditions for Harbor House. And refer me again to the place where I'm going to find your indication about decision-making by the manager and the HOA board, because I'm not finding it here.
No, it's under bylaws. So keep going. You're got to go all the way to page 39.
The handwritten 39?
Yeah. Sorry. Yes. And
No,
on my
that's
right,
okay. Appreciate people's efforts to try to
to
do
clarify it.
that.
There's three things that guide us. One is the declaration, which is also known as the CCRRs. And then there's the bylaws, and then there's the RCW. But I'm afraid that Ms. Jarvis has the wrong RCW. I can point that out in the CCRR that she has the wrong one, if that would be helpful. And why it's the wrong one. I can do that. It'll tell you right there.
Okay.
Want me to do that?
No, I just found your bylaws. So.
Okay.
The issue with submitting things electronically, which is great, I can't just go one to the next. I have to go through every single page in order to reach whatever is loaded up after that. So it takes a long time to go through these.
Yeah, I got it. I went to my paper copy.
Yeah.
Yeah, I understand.
Okay. So I do see no major improvements shall be made to the common areas without consent of the majority of the management group.
In my experience was that Jerry usually did that if it was like a big sum of money.
So you've been at the condo for how long?
14 years.
Okay. And Mr. Riley was the manager for some
18
significant
years.
portion of that time.
Yes, he was the manager until December 7th of 2025. So he was manager for 18 years.
Okay.
So before me.
Yeah. And did you know him to make financial decisions regarding improvements without going to the board? Did he occasionally do that? Did he never do that? Tell me.
He occasionally did that, but they weren't major.
Okay. So would he say $3,547 is major, or would he say that's not quite major?
I would think he would have said that was major because he did go around and talk to everybody about the tree trimming that was done that was $3,250. That was that same year.
And decision was made that that was an HOA obligation or a personal obligation?
Yes.
Which?
HOA. That was an HOA.
Okay.
And if I may add, when he went around and asked about the tree trimming, he just suggested that he was going to get some trees trimmed. There was no talk of cost.
That's true.
And it would benefit him with his view, and not me, but I was new, so I'm happy to do whatever the HOA manager wanted done, including some fixing of a sidewalk in front of Miss Adams' unit. So there were lots of things getting done to improve the property. And he was clearly in charge and making sure that the projects were funded. So I had no idea that there was a process step that might not have been done because I trusted that he was the HOA manager and in charge of our funds.
Okay. All right, so right now I'm looking at RCW 6434240, alterations of units, and this was an amendment to that original statute. It was adopted in 1989, and it's effective through January of 2028. And it talks about, among other things, alterations in electrical systems in the condominium. And it says, the board of directors shall approve a unit owner's request within 30 days or within such other period provided by declaration, unless the proposed alteration does not comply with this chapter or the declaration impairs the structural integrity of mechanical or electrical systems in the condominium. And then it says the failure of the board of directors to act upon a request within such period shall be deemed approval. Ms. Adams, any comments on that statute?
Yes, sir. That it does not cover our condo. We were established prior to 1990, and the 64.34 RCWs are after. And I have that actually stated on page 37. Actually, it's on page 38 at the bottom of my stuff. It says condominiums, it says notes on that page 38. And it says condominiums created after July 1990 is chapter 64.34 RCW. When you go to our declaration and you go to page, I think it's like 3 or 4, you find, no, it must be 3. In 1.8, under the definitions, no, it's actually under the, sorry, my fault. It's under the CC and R, the declaration, and it's under Article 1, and it's 1.18 section, and it says the condominium statute shall mean the horizontal property rhymes act of the state of Washington laws of 1966 or 63, chapter 156, presently codified in chapters 64.32, the revised code of Washington. So since this was, we were filed.
Tell me, which of your
Yes.
pages?
Okay, which pages is that? It's 7. Excuse me. I had it.
Your handwritten pages.
It's 9.
Okay, thank you. Okay. And that's part of the CCNRs adopted by Harbor House.
Correct. Back in
Okay.
1982.
All right. Yeah, and so I think what you're telling me is that the state can't come in and change the obligations to comply with the statute that has subsequently been amended. Is that what you're saying?
Not sure what that
A
means.
1989 statute was adopted, different than the 1963 statute, and you're saying that
Correct.
because
Yes.
the CCRs doesn't recognize the 1989 statute, it should not apply?
Right. The 6434 does not apply. And that's actually stated in the pages that I have in front of you. It's on page 38 of my stuff. And it says notes at the very end of all the list of ones, the RCWs that pertain to us. Then it says notes. Condominiums created after July 1st, 1990 is chapter 64.34 RCW. But we're before that, so you're absolutely correct, sir.
Okay. That is I was curious what note it was, but it's a note actually put in there by the legislature.
Correct.
Okay.
Because they probably have problems where people pull the wrong one for condominiums. And that complies back with the declaration that we just went through, the Article 1 and the Section 1.18.
Okay. Thank
Okay.
you. And Ms. Jarvis, did you have anything else you wanted to add?
I, I guess I would just like to understand why the current RCWs don't apply. I think that's what I'm getting from this, is that
Well, the legislature indicated in its notes to the statute that was adopted in 1989 that it would only apply to condominiums starting in 1990. So they call that a grandfathering clause. They do that occasionally when they adopt legislation, say it doesn't apply to things previously existing, but it does apply to new things going forward. That appears to be what they have done here.
okay. So could you tell me how that applies to this then, specifically as far as the ownership and responsibility?
That the 6434 statute is not applicable. So it looks like you go to 6432 as the applicable statute.
Okay.
And then, among all the other things, you have the bylaws, you have the CCRs, and the various issues raised by both of you in this case.
It seems like our CCNRs echo the later RCW laws. And that's what I was looking at as far as the common areas defined as pipes, wires, conduits, antenna, and other fixtures and equipment for utilities. So I don't know, it feels like it's more of the same in the sense that the condo owners are not responsible for the external structure, infrastructure, outside of their immediate condominiums and paint in, floor up, that kind of thing.
Right.
I mean, I was just going on the judgment of our HOA manager who was involved with every step of this project and took the responsibility of paying for it.
Yeah. So, Ms. Adams, the HOA in last fall paid the electrical bill, and then upon Mr. Riley no longer being the manager, reviewed that and decided that the obligation was Ms. Jarvis's. Is that correct?
Correct. Except for the tree light.
Right. Yep. I understand that.
Because it was her shed.
Right.
I don't own the shed. I have exclusive use of the shed.
Okay.
The shed is part of the carport. It's part of the main building. It's part of the overall.
No, it is not part of the main
Oh,
building.
okay.
It is a
Yeah,
separate
I
structure.
don't need a debate here on that issue.
Okay.
I'm sorry, I apologize here. I lost Mr. Riley's note indicating his review of the budget that was in somebody's exhibits. I thought I had it, but
September, yeah, it's on September 19th. Hold on.
and where is it in somebody's exhibits? Yeah, I know I saw it at least once.
Yeah, me
You guys-
too.
I think it's page 55, 56
Of whose exhibits?
of
Mr.
Jarvis, 55, 56.
Yeah, that's it. I know Ms. Jarvis said that it was, that he was able to put that together, but he used the budget from the year before and he couldn't reconcile the bank statement.
Yeah.
Okay.
All right, I found it. I apparently skipped right by it.
It's easy to do, lots of pages.
And I think I have one last question. Ms. Adams, as a manager, I'll ask you, when there's an issue for HOA consideration, how does that work? What's the process for getting, I think that you said there are only 4 units, is that right? Or
Right,
that's my
correct.
understanding?
Yes.
So there are 4, there's a manager and then there are 3 board members. Is that how it works?
Yes.
And what does a manager do when there's a matter for HOA consideration?
Just ask for a vote. Usually we do it electronically because they're all very, very busy people. And we give 14 days time to respond.
Okay.
Okay.
All right. And that's been the process for how long?
Quite a long time for the special votes. We usually have an annual meeting, but we haven't even been able to. My gosh, excuse me. We have, I don't know how to turn it off. Oh. Okay, sorry. I didn't know which vote it was. Okay, so I'm sorry, I've lost track of the question.
Quite. How long has this process been in effect where they
Oh,
have to
okay.
pull?
We used to have annual meetings that we met in person, but when COVID came up, then we stopped having them, and now we've just continued it with having it annual meetings with doing it by electronic as well.
Okay. All right.
Okay.
Thank you. Right. And that's as you can tell with the time we've spent on this case, that there are a lot of interesting issues here which are very
Oh, there
close. This is a civil case, and the way I have to decide the case is just by what's called a preponderance of the evidence, which just means I'm going to decide who's slightly more favorable than the other by way of the arguments they're making. So in this case, there are a bunch of issues. One is the property, personal property or common property. It appears to me from a a variety of things that have been said today and reviewing some of the documents that the property, generally speaking, is personal to Unit 3. So the benefit for the electrical change, even though it may have enhanced some safety for the common area, is basically to the benefit of Unit 3. However, the owner of Unit 3, Ms. Jarvis, apparently got the approval of the then manager, Mr. Riley, to do the work, and Mr. Riley sounds like eventually paid for it out of HOA funds, and everybody seems agreed that that's what happened. I inquired as to what was the authority of the manager, and the bylaws indicate that for major improvements, and it doesn't define major improvements, that the manager, in order to make a decision, has to have the acquiescence of the board. And in this case, clearly that didn't occur. It was Mr. Riley's determination that this expenditure was okay, and appears to, by implication, reading all the documents, appears to have authorized it basically by the fact that he paid for it. I do realize that the bills were sent directly to Ms. Jarvis, and Ms. Jarvis did provide an email she sent to Mr. Riley saying that she was going to have the bill sent to him. And I'm going to guess that he subsequently paid after those bills were sent to him. So theoretically, she was relying on him to have the authority to pay the bill on behalf of the HOA. So I don't think Ms. Jarvis's reliance was totally inappropriate. On the other hand, it appears to me that based on the bylaws that Mr. Riley did not have the authority to authorize the expenditure of $3,547, which is somewhere between, it's probably 35-36% of the HOA's annual budget, which in my mind would indicate that it's a major improvement. So when you're talking about something that's 1/3 of the budget of a funding agency, in this case the HOA, that to me is a major improvement as contemplated in the bylaws. That I'll find that Mr. Riley did not, in fact, have the authority to bind the HOA to the costs for the electrical upgrades to the shed and the storage unit. And even though Ms. Jarvis has a strong argument for her ability to be able to rely on what the manager says, in this case, I don't think the manager had the authority to make that statement. So I will deny the plaintiff's claim. Thank you all.
Thank you, Your Honor.
Given that, we want to know where we put the electricity for the storage.
You're going to have to consult with counsel. I can't give you advice on that.
Okay. All right.
Okay. Thank you.
Thank you.
Thank you.
A $3,547 electrical bill turned a simple condo dispute into a courtroom showdown. Ms. Jarvis argued the electrical work was necessary for safety and claimed the former HOA manager, Jerry Riley, approved the project and paid the bill using HOA funds, but the HOA pushed back. They argued the disputed shed was private property, and the work mainly benefited Unit 3. More importantly, the HOA's bylaws required approval from the management group for major improvements. Then the judge uncovered the key problem. The project cost $3,547, roughly 35 to 36% of the HOA's annual budget, and there had been no board vote. The judge acknowledged that Jarvis had a strong argument because she reasonably relied on the former manager's approval. But reliance wasn't enough. The manager simply didn't have the authority to commit the HOA to an expense that large. So after weighing the evidence, the judge delivered his decision. Ms. Jarvis's $3,547 claim was denied. One missing vote changed everything.